If we have settlement discussions during the course of your case, and the case does not settle and goes all the way to trial, can the defense tell the jury how much money we wanted to actually settle this case? What do you think? Can they do that? You want to know the answer? Come join me for a moment as I share with you exactly why they can't do that. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now the doctor denies all of your allegations. But during the course of your lawsuit, the defense actually approaches us and begins settlement negotiations. And we come right out and tell the defense how much money we need in order to settle this case to compensate you for all of the harms and losses and damages that you incurred. And now, through the course of negotiation, we cannot reach an agreement. And now the case proceeds to trial. We now get to trial. And now during opening arguments, I tell the jury what our case is all about and how the doctor violated the basic standards of medical care, causing you significant harm and injury. It's now time for the defense to get up and give their opening argument. Can the defense attorney tell the jury, ladies and gentlemen, we don't think we did anything wrong. But guess what? During the course of this lawsuit, we had settlement discussions and we were this close to settling this case. Oginski and his client wanted $5 million. Can you believe that? And now, is that appropriate? The answer is no, it is not appropriate. That would prompt me to jump up out of my seat as if an ejection button were pressed, to yell out, "Objection, Judge! That's improper. I demand a mistrial. And I ask that you sanction my opponent." Now, what have I just asked? I've asked the judge to do a number of things. I've asked the judge to recognize that what my adversary did was totally improper. And in all likelihood, the judge will admonish or yell at the defense attorney knowing full well that that's improper. But now, the fact that he has discussed with the jury, the fact that we have been negotiating before we got to trial, that's improper, as well as discussing the amount of money that we were asking for in order to settle this case. Now, why is that improper? It's improper because the jury's function has nothing whatsoever to do with trying to settle this case. You see, the parties to this lawsuit have been unable to settle this case. There are different issues that have arisen, and now we can't reach an agreement. So, we need 6 members of the community to now decide whether or not your doctor violated the standard of care. And if so, did those violations, did that carelessness cause you harm and injury? And if so, how much money are you to receive for compensation for all of the harms and damages and losses you suffered because of his carelessness? That's what the jury is there for, to decide those key issues. The fact that we may have tried to negotiate this case during the course of the lawsuit is insignificant and meaningless for the jury's purpose. It is insignificant for what they are there to do. If my opponent were to now tell the jury about the fact that we had settlement discussions, we couldn't reach an agreement, and how much money we were asking for, those are all improper things to say to a jury at any time during the course of the lawsuit. And now the fact that my opponent has told the jury this, you can't unring the bell. The jury has already heard it. It's significant enough that it may warrant the judge telling the jury this case is over before we actually started the case. In that instance, the judge would likely excuse the jury from jury service and tell the attorneys now to go ahead and pick a new jury and start all over again. And I guarantee you the judge would not be happy with my opponent. So why do I share this with you? I share this with you because this comes up from time to time when a client asks me, what happens if the defense attorney mentions something about our settlement negotiations breaking down during the course of trial? Well, now you know the answer. I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and your matter happened here in New York, but you're thinking about bringing a case and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.